So in constitutional law, I've looked at a few of the cases which you've been an advocate for unchecked executive spending. Do you think that the checks and balances that we have embedded in our system, in our legal system, are a good check and balance on government accountability?
Let me answer that this way. You know that I think most people know that Americans revere their Constitution, and you might say it's almost a constitutional cult where the Constitution, Donald Trump was selling a Bible, a Trump Bible, a few months ago, and on the cover of it is the word Bible, and then underneath it is a logo of the US Constitution, as though they are equally to be revered in a sacred way. So they have that kind of attitude towards their Constitution. Australians don't. And if you look in the Australian Constitution, you won't find the words rule of law, and you won't find the words separation of powers, and you won't find the words judges should be independent and impartial. You won't find any of those things. You won't find the words prime minister or cabinet, for that matter. What you will find is a set of very technically written legal propositions that say the legislative power of the Commonwealth is vested in the Parliament of the Commonwealth. The executive power of the Commonwealth is vested in such and such. The judicial power of the Commonwealth is vested in the High Court. It's very dry reading, and it's very hard to get emotional about it. So we have to ask the question, in Australia, we each of us have a set of beliefs about human rights, the right not to be imprisoned without a law saying that you committed an offence for which you can be imprisoned, the belief that nobody can come into your house and interfere with what you're doing there, or nobody can interfere with what you're doing anywhere unless there's a law that justifies that interference. Whereas in some countries, a person wearing a police uniform can do anything that they want. So there's nothing in our Constitution that has the words, you must not, no person must interfere with another unless there's a law justifying. Those words don't appear. So when one asks the question, does our Constitution adequately protect our rights? The answer is yes, but the mystery is how it does so without saying any of those things, such as in the US Constitution, one of the crucial amendment provisions says that everybody is entitled to due process according to law, which means that you can't be arrested unless there's a lawful warrant for your arrest or another just cause for your arrest and so on. We don't have anything like that. So how does it work? The way it works is that when the men who drafted the Constitution, they're all men, in the 1890s, drafted the Constitution and had it passed as an English law governing Australia, they believed that it was the law of England and it should be the law of Australia. And it needn't be stated. It was the law that nobody could interfere with you unless the law justified it. It was the law that judges should be impartial. It was the law that judges must not have an interest in the case, either by government connection or any other connection. That was the understood assumption about how we behave. And so those laws, those people believed, didn't have to be stated. We just needed a set of provisions that could establish a government, could establish a parliament, could establish a judiciary, and the rest would be taken care of by the laws that we understood applied without their being written down. Now, so long as we hold to those common assumptions, then the Constitution is a perfectly good one. If you Google Constitution of the Union of Soviet Socialist Republics, that is the USSR, Soviet Union, if you Google Constitution under that subheading, you'll find a constitution in which there is a Bill of Rights. Freedom of speech was guaranteed, but if you exercise freedom of speech in Russia, to this day actually, but even under that constitution, if you exercise your right to free speech and criticize the government, by the time you got home, there'd be a policeman waiting for you to take you away. So having ink on paper can mean a lot, but it can mean nothing. What really signifies the way that a society lives is the set of unstated assumptions, which are only stated expressly in moments of trouble. If somebody is arrested without a law, then somebody in court will say that that's a breach of the unstated assumption, that you can't be arrested without a law saying so. But otherwise, thankfully, we take it all for granted. And therefore, when we have constitutional troubles, by that I mean, say, a government minister who's corrupt in a way that's perhaps not against the law, a government minister who takes expensive presents from a very rich person who wants the law changed, then these assumptions come into play, and that minister gets generally dismissed from office and is treated with contempt. So the Constitution is there and does its work. And when not only do unstated assumptions come into play and are articulated in moments of crisis, but when a question is raised about how something really works, then a judge might have to trace through the operation of our common assumptions about rights in law, the unstated ones, and work out that actually provisions of the Constitution that say nothing about them are founded upon those assumed laws, and those assumptions must be given effect. For example, there was a man called Lange, L-A-N-G-E, who was the Prime Minister of New Zealand, and he sued a media company for defamation. He said that they said terrible things about him and ruined his character. And the media organization took the point that what was being discussed was politics, and you can't have the system of government we have, which is democratic, unless the people who vote in a democracy have information, accurate information. And one of the important ways that people get accurate information is through newspapers and media organizations who report on things. So if there's a restraint on the publication of those things, assuming they're published in good faith and not in a nasty way designed to hurt somebody and for no proper reason, but assuming they're published for proper reasons, then you can't restrict what they say. They're free to say whatever they like about political matters. So you can see that our Constitution says nothing about free speech. The words free speech don't appear in them. But what the judges of the High Court said when they decided that case was that when you look at the provisions that say there shall be a parliament, the parliament shall be elected by people of Australia, members of parliament should be elected by vote, and so on. The assumption underlying it is invisible, but when you peel away the layers, they are there in the Constitution because they're the assumptions of law that underlie it. So to answer your question, our Constitution, Justice Keane was a judge of the High Court from Queensland, and he gave a speech once comparing the Australian Constitution and the American Constitution, and he likened the American Constitution to something like a peacock. It was large and colourful and beautiful, and ours to a little brown sparrow that you don't notice. And it's good that we don't notice it, because in essence nobody in this country is running around insisting upon their right to do this or their right to do that. We take our rights for granted in an understated way, usually in an unstated way, but when it matters, it comes out and it's applied faithfully and strongly by the judges, and also by other parts of the community who are, they're conscious of it. There was a time when in Queensland, the government of the day was going to appoint a person to be a Supreme Court judge, and I felt very strongly that this person should not be appointed as Supreme Court judge because he had shown really that he was a supporter of the government by everything. A lot of things he'd said, he showed that he wanted to help them execute their policies. Well, that's the last person I thought you want to be a judge, and nobody was saying much about it. So I stuck my head up and wrote something, and the newspapers published it. So and I went on TV to explain my thinking about why I thought it was a bad appointment. And because you can't have judges, as I said, who are there to faithfully support the policy of the government. They're there to apply the law, nothing else, whatever the policy of the government is, because of the separation of powers. And I was at home one morning, and we were having our pool deck rebuilt, and the carpenter who was doing it was there that morning, and he said to me, "You've been on TV lately?" And I said, yeah, I have. And he said, and this is a man who had very little formal education. He was a carpenter, so he'd done high school. To what level, I don't know. He didn't strike me as a reader. We never had any conversation at the time he was there that suggested he'd read a lot of books, or that he read a lot of theoretical books. So, but he'd seen me on the news talking about this thing. And so he said, you've been on TV. I saw you on TV. And I said, yeah. He said, it's the separation of powers, isn't it? Now that, I almost fell over, because how did he know? How did he know? He knew that there was a discomfort involved in what I was attacking, that there was something wrong with it. But he even knew what it was called, or thought he did, and he was right. And the impressive thing isn't that he could put a name to it. The impressive thing is that he understood, like almost all Australians do, that there are these principles under which we live, which restrict the power of government to keep us safe from tyrannical uses of power, wrongful uses of power, that restrict government in a good way. He knew that. And I think almost everybody knows it, although if you ask them to explain it, they might not be able to, and they might not be able to give it a name, but they know. So the strength of our constitutional arrangements lies not just in the very boring technical language of our Constitution, which says nothing about rights, but in the unstated assumptions of the law that the judges understand and apply when they have to, and that the people of Australia understand and believe in.
Thank you for that.